with me is Aaron Howell, and I'm going to have him introduce himself. And then we have Kerry Doyle, as I'm sure most of you know, and Juan Acosta, who is the Assistant Director of Field Operations. Aaron?
Thanks, Amanda. Thanks to all for joining us. Thanks especially to Kerry Doyle and Juan Acosta. My name's Aaron Hall. I'm based in Denver, Colorado. I'm on the ICE AILA Liaison Committee along with Amanda, and I'm going to pass it to Kerry and Juan for brief introductions, and then we will get to the questions.
Hi, thank you, Amanda and Aaron, and want to take a moment to say congratulations to AILA for its 75th anniversary. Very exciting for the organization. We're always happy to be here and to engage in the conversations. And as you know, I'm the principal legal advisor since September of 2021. And it's been really an honor and privilege to serve in this position, and I'm happy to see all of you here, and we'll do our best to keep communication open with AILA and with all of you as we move forward with the administration's agenda to create a more humane and just immigration process.
Hello, everyone. Thanks for allowing me to come and speak with you today. Communication is important, specifically for enforcement and removal operations. My name is Juan Acosta. I'm an Assistant Director for Field Operations in Headquarters, and my job is to provide guidance, leadership to the 25 field offices that represent ERO throughout the nation. Thanks again.
Okay, so the questions that we have here, thank you to the membership for sending in questions over the course of the last month or so to help fill out our agenda today. I wanted to point out that on the AILA app for this conference, there is a Q&A feature, and if you submit questions there, we will try to get it to as many of them as they can. We're going to start with ERO and some questions regarding alternatives to detention and those programs. Mr. Acosta, given the large increase in the number of individuals in the ISAP program, can you talk about the role of the ISAP case manager? Specifically, what are they required to do? What are they prohibited from doing? How do they engage with ICE ERO officers? And when and how should individuals and attorneys engage with ICE officers in regards to their ISAP case managers?
Well, thank you for that. ICE Alternatives to Detention programs, through intensive supervision appearance program, contract uses technology, case management, and other tools to manage an individual's compliance with release conditions while they're on ICE's non-detained docket. The ATD program is carried out with the support of a government contractor. It's currently BI Incorporated, who supervises participants through a combination of home visits, office visits, alert responses, court tracking, and technology. Under ATD, ERO officers have the discretion to determine the frequency of home and office visits, the type of technology used, whether it's telephonic, GPS, or SmartLink, and whether or not to assign court or alert management. Case management levels and technology assignment can be reviewed and adjusted by the ATD officer at any time, depending on a change in participant circumstances and compliance. But to your specific question, a BI case specialist provides case management for program participants and assesses and determines appropriate referrals for program participants to facilitate community stabilization. We've recently modified that contract to ensure and to clearly outline to the vendor that attorney legal representatives are able to present during participant check-ins with the vendor.
And would that representation be in person, by telephone, either?
It can be either.
At the AILA Spring Conference, we had discussed whether ICE might be willing to figure out a way to allow for online change of address, similar to the way that USCIS does it on Form AR-11. Do you have any updates for us on any progress there?
So per President's Management Agenda and Customer Experience Executive Order, DHS is working to identify high-impact public-facing services within DHS components that can be improved to enhance the public's experience when interacting with the federal government. In coordination with ERO, the ICE Office of the Director, we've identified a G28 form filling process and legal representative detainee call visit scheduling process as the two are interconnected services that can be improved to significantly enhance customer experience for non-citizens and their legal representatives when interacting with ICE. The solution includes a centralized website that allows legal representatives to register for an account and complete, sign, and submit an electronic copy of the G28. In addition, there are tentative plans to include a scheduling tool that allows a legal representative to select a detention facility and schedule a call or a visit with their client that can be confirmed by the ERO office or the detention facility. We hope that this will standardize, centralize, and streamline the form submission and a call visit scheduling process while giving ERO officers, detention facilities, and OPLA the visibility, the sharing, the reporting necessary to remove any inefficiencies identified with the current process. We expect this process to take roughly a year and plan to engage both our non-citizens, the legal community, and other stakeholders for their input as we weigh into this process.
In the interim, while you're standing up that program, what's the best way for an attorney or a non-citizen to communicate with a local office if they wish to move or change jurisdiction or move a check-in appointment?
The best ways to communicate with that particular field office directly, and I encourage all of our staff members to reach out to your local field office director and your local supervisory staff there, to go online to www.ice.gov, look at our public-facing websites and public-facing information to give you an idea of who to contact in your specific area, and also to look out for our Office of Public Engagement that have our community resource officers that can also help in answering a lot of those questions.
I would just note for the membership that the outreach email addresses for ERO offices are published on the AILA website and on the ICE website, and so that's, I think, generally a good place to start. The next question is about the de-escalation of electronic monitoring. So according to the ICE detention management spreadsheet, the average length of time that a non-citizen is subject to electronic monitoring or telephone reporting is over 404 days. Will ICE de-escalate the participants' electronic reporting requirements or permit de-enrollment before the end of proceedings, before the immigration judge makes a final order? And if so, what factors will ICE consider?
During initial consideration for enrollment onto ATD, non-citizens are assessed for participation in the program. Their current immigration status, criminal history, compliance history, community and family ties, being a caregiver or provider, or other humanitarian considerations or medical considerations are taken into consideration as to the level and the form of alternatives to detention that they're going to be placed on. Under normal operation protocols, ATD participants are regularly assessed for continued placement in the program and for the potential de-escalation or escalation dependent on the assessment of new information. Like those listed above, current immigration status, criminal history, etc. Due to the number of ATD participants traveling from the southwest border to interior city locations who have not been fully processed and issued a charging document, the ability of ICE to continue to fully reassess ATD participants has been limited, but it still exists. Due to the length of immigration proceedings, it is unlikely that ATD participants will remain on some type of technology, that some de-escalation based on the circumstances of the case will arise. Escalation can arise also dependent on those factors that I have mentioned.
I'm not sure that I understood that last part. So did you say that it's likely that de-escalation will arise due to the length of proceedings?
It is unlikely that they will remain on an electronic type of technology throughout their proceedings, but depending on where they are in their case, depending on their participation, compliance, or other factors, we can de-escalate or escalate as necessary.
Okay, thank you. Is there, are there standards or benchmarks that field offices are asked to use? For example, would ICE be willing to consider set time periods, say 60 or 90 days, or the attendance at an initial master hearing, or the filing of an application for relief as a benchmark for consideration of de-escalation?
There is not a categorical way that we are going to establish that benchmark, because de-escalating or escalating is on a case-by-case basis based on compliance, the case status of that particular individual, the formal adjudication of the immigration judge, where we are in the removal life cycle, has removal been ordered, et cetera, is going to allow the case officers to understand where they are in that particular unique circumstance for each individual case, and de-escalate and escalate as appropriate.
And, under what circumstances will ICE unenroll a participant from SmartLink? Is there any difference between that and other alternatives to detention?
There is no defined litmus test for placement on continued participation in ATD. That's not part of each case has to be taken on its individual circumstances and individual unique set of facts in order for us to enroll or disenroll somebody from SmartLink.
And should individuals or their attorneys be making an affirmative request for de-escalation, or is that an automatic review process?
Our officers are reviewing those cases on an ongoing basis as they review all the cases under their purview. But attorneys can request that based on how the attorney feels that they should handle their case.
I think I would say that I'm happy to hear that that you think that most people will come off of electronic monitoring during the course of their case before an IJ order. I think our membership has expressed a concern that that SmartLink would become the default, that most people are seemingly subject to electronic monitoring, whereas before people were able to simply show up at their court dates and trusted to do so. So it wasn't truly an alternative to detention, rather just additional electronic monitoring. So we're happy to hear that there is de-escalation from that as well.
I want to add there that based on the length of immigration proceedings, it's unlikely that a participant will remain on ATD. But each case, I want to make sure that it's considered based on its merits.
And is there standard guidance on the factors that are being considered on de-escalation that's issued to field offices? I know it's case-by-case basis, but do we have some kind of standard guidance, because it just seems to be a wide variance around the country?
There's several things that we're looking at when a person is released from custody. They're free to move about in the community while they're released on an alternative to detention, so they are not detained as they're going through removal proceedings. And what is being looked at by each individual field office is that current immigration status, their criminal history, compliance history, community and family ties, being a caregiver, provider, or humanitarian considerations, medical considerations, and those can change over time, resulting in a de-escalation or escalation of monitoring.
And can you confirm whether a person is required to download the SmartLink app to their personal device, or whether they're able to continue to use a government-issued device for participation in the program?
So participation in the program, for those that are eligible, they're handed over a device from the government. If they have their own device, we recommend that the app is uploaded into their device more for comfort, so that that person doesn't need to carry two devices if they're already carrying their personal cell phone. So it is up to the non-citizen. We will encourage that. Those smart link devices are not they're a finite resource, and those have to be recycled for additional participants that are coming in. So if the non-citizen does have a device where we can suggest to have that ATD, that Smart Link app uploaded into it, I think it'd be a little bit more comfortable for the non-citizen not to carry two devices.
Okay. At our spring engagement, ICE, I think, indicated that they'd be willing to issue language to the fields reminding that some asylum seekers could not apply for travel documents. And we wanted to ask whether that instruction has been communicated, and whether the inability to apply for travel documents from one's home country, confirming that it would not be a negative factor in considering de-escalation.
So for asylum seekers, travel documents are needed for identity and removability. However, the assessment regarding escalation, de-escalation is based on cooperation and made on a case-by-case basis. Individuals who cannot obtain travel documents because of persecution or asylum-related concerns would not necessarily face escalation. ERO will consider clarifying language for those respondents who can technically obtain a travel document, but where doing so could undercut their asylum application. In order to remove a foreign national from the United States who has been ordered removed, ICE generally needs a valid unexpired passport or other travel document. Must be issued by the non-citizen's embassy or consulate of nationality to facilitate the non-citizen's departure from the United States. In most cases, a travel document request, that process begins after the issuance of a final order. For cases where a valid TD is not available, ICE prepares and forwards that travel document request to the appropriate embassy or consulate. This request contains supporting documentation required by the consulate regarding its national, including but not limited to the individual's identity documents, criminal convictions, and applicable portions of the immigration proceedings. But we, as ICE, are required to redact any inferences to an individual claim of fear of returning to their home country, asylum, CAT, or withholding of removal, etc., whenever we are requesting a travel document.
So I'd like to turn now to post-order check-ins. ICE's capacity for post-order check-in appointments has been limited in many field offices. They have, under the prior administration, these check-ins became more frequent than in the past, which were in the past were more like once a year. And during COVID, these check-ins were largely rescheduled. Will ICE permit continued rescheduling by email at all offices and honor those requests so long as a written transmission has been made?
When releasing a non-citizen from ICE custody, officers establish the minimum reporting requirements and reporting frequency for a year after the release. Criminal non-citizens are required to check in once every 2 months. Non-citizens without criminal records are required to check in once every 4 months, and asylum applicants are required to check in once every 6 months. After non-citizens released from ICE custody complete in-person report-ins for 1 year and adhere to the reporting frequency requirements, the field office director, or the senior most person in that particular field office, or his or her designee, may change the reporting frequency at his or her discretion after reviewing the non-citizen's case and the adherence to the reporting requirements. In short, ICE FODs, field office directors, or their designees are authorized to adjust the check-in frequencies when taking into account the individual circumstances of a non-citizen's case.
And by that, do you mean that they must physically check in person, or it would, see, our issue is that with the long lines and crowded offices, and it would be nice to continue the rescheduling by emails or some other method. rather than requiring these people to stand in long lines like in Miami and, I'm sorry, requiring people to stand in long lines like in Miami. And
What I can say to that is to make sure that we are advising our non-citizens correctly. They should report when they are ordered to report, and that you reach out to your local field office to see if there's a way that you can engage in communication with the FODs in order to change that frequency. But stress that do not miss your reporting requirement.
so that's on a per field office as to whether they're going to allow any alternative.
Correct. That will be the field office director or their designee to have that discretion.
And will ICE consider moving to telephone check-ins and address updates for large numbers of post-order cases?
As a blanket brushstroke, I don't think that that's ever done. I think on a case-by-case basis, ICE will definitely consider how a person's reporting requirement is needed as they remain on the non-detained docket.
So what office never replied to reschedule request or was closed during COVID and never issued it? What about if an office never replied to a reset schedule request or was closed during COVID and never issued a new date? What's the individuals to do about that?
Please re-engage. Please re-engage with our field office. Our field offices are busy. Please give them an opportunity to reply. Seek out our website, www.ice.gov. Look at detention practices. Look at our Office of Public Engagement. I believe it's also on the AILA website. And give us an opportunity to re-engage that particular case and get you a response.
Thank you. And if we can move now to detention and access to counsel and transfers, can you confirm whether the Fryhat preliminary injunction and other COVID-related orders remain in effect, given that the Fryhat plaintiff's petition?
Let me refer that
Name's
to,
on
to
Juan's like, wait, can my lawyer do that? Sure, happy to step in. So at the moment, Fryhat injunction is still in place. There are, I can say generically, there are ongoing settlement talks in that case. So as at the moment, it's sort of frozen in place, right? So the mandate hasn't, even though the district court ruled in the government's favor, that mandate hasn't issued because the plaintiffs are still have the option to make a filing to request a rehearing en banc. And so that's sort of frozen. We've been getting, there have been continuances of the rehearing en banc deadline. So Fryhat is still in effect. We are still following the injunction in that case. ISIS, ERO, is doing that on a regular basis and doing Fryhat reviews as required under the injunction. As you may know, PRR 9.0 came out on Tuesday? I don't know, this week. I think Monday, actually. I think they pulled it off Monday. So I think end of the day, Monday, there's a new PRR. So I would refer you to that because that will be the new guidance. It's the new guidance going forward that CDC has reviewed and cleared for all the detention facilities moving forward. But Fryhat reviews are ongoing at this moment.
and for any follow-up for ICE reviews, if you need to contact the field office in order to make sure that the person is getting a Fryhat review so that someone can look at that particular vulnerability, I want to remind you of the designated legal access points of contact and also to go to www.ice.gov detain. You'll be able to see there on how to communicate with your local field office.
Thank you. So can ICE provide data about the number of requests for release from detention it has received under the current enforcement guidance? And can they share the approval grant rates?
We've not made that information public at this time, but perhaps it will be made available in the future.
Okay, so can you provide us further information about ICR or ICE case review, and what's the average response time for such cases, and how many cases have been submitted since implementation, and how many cases resulted in release under ICR?
Sure. The ICE case review or ICR process, response times vary based on case complexity and research needed, as well as any senior reviewing official follow-up or clarification needed from field office leadership having jurisdiction over the case. In most instances, response times do not exceed 3 business days. Since the inception of the ICR process, roughly around March of 2021 through June 10th of last week, 2,934 cases have been submitted to the senior reviewing official. Of those cases, 1,396 were returned as either not having yet been reviewed by the field office or not meeting case review criteria. In short, please engage with the local field office director having jurisdiction over that case so that those questions that you may have for case review are handled in that specific area before submitting to the senior reviewing official. And of the 1,538 cases reviewed by the senior reviewing official since its inception, 230 were released following that review.
And actually, I had a follow-up question on the Freiheit. Kerry, can you clarify what is a PPRI?
Oh, it's PRR.
PRR.
Pandemic.
That's ICE pandemic response requirements.
Requirements, there we go. Thank you, Lauren.
www.ice.gov/coronavirus/PRR.
I'm still learning all the acronyms. So, but basically, the PRR, what it does is it is the CDC guided standards that are used by ICE in their detention facilities to assure protection to the ICE detainees with regard to the COVID pandemic. So it sets out guidelines for how the detention facilities should again, protect the detainees during the pandemic. And it was updated because CDC issued new guidelines probably a month or two ago in general, but also more specifically related to congregate settings. And so in light of that, the ICE prepared, again, in consultation or review by CDC, the updated PRR. So pandemic
Response
requirements. See, we're a good team.
Mr. Acosta, could you give us a list of all of the legal access contacts in all facilities? That was a follow-up.
That was a follow-up. Those are internal ICE resources whom are leveraged to address legal access issues within the 25 areas of responsibility. I think you could get more information on who those are on www.ice.
Okay. Thank you. Can you provide an update on the free minutes program and to confirm that ICE tablets should be allowed for calls up to 60 minutes with attorneys?
As of April 2020, in recognition of the coronavirus disease and that pandemic, the impact that had curtailing visitation, in-person and social visitation, ICE began providing 520 free phone minutes per month at 39 of the primary facilities where our communications contractor had ICE tablets deployed. That contractor provides tablets that have a phone dialer capability and allow usage of the 520 minutes issued in 13 10-minute increments. These free minutes allow detained non-citizens to call anyone, family, friends, attorneys, both domestically and internationally. The list of those facilities can be found on the ice.gov website. ICE has also worked to provide free minutes programs to facilities not covered by that particular contractor. Non-citizens may make multiple 10-minute calls as long as they have available free minutes. Calls may also be paid calls either by the non-citizen or the caller or the recipient of the call, and can be of any duration limited only by facility-specific requirements. Non-citizens are always able to call attorneys on the approved Department of Justice Executive Office of Immigration Review speed dial list for free, unmonitored, unrecorded, and the duration is only limited by facility-specific requirements. At the contractor-covered facilities, this applies to both wall phones and tablets. At other facilities, this applies to wall phones.
Okay, thank you. Can you confirm that every detention facility used by ICE offers some ability for confidential legal calls, unmonitored and unrecorded?
Yes.
Okay. And can you provide us a summary of the different ways an individual may access confidential legal calls depending on that type in the facility?
At each of the facilities, there is a prevailing detention standards. I encourage all of you to educate yourselves on what standard applies to that specific facility at that time. And then when you're looking at that particular standard, you're gonna check for telephone access. You're gonna also have attorney calls in that particular standard, and that will give you an outline as to how to request your number to be placed on an unrecorded, unmonitored list. And I do want to say that attorney calls are privileged. Our agency understands that, and our agency will not, our agency will not use that call or cannot go into that recording without any appropriate legal action.
And so has ERO published guidelines on how to contact the legal access point of contact for every facility, so that their confidential calls may be requested?
To obtain information, and to make sure I answer the right question, to obtain information on how to schedule a confidential legal call at a particular facility, individuals should review the instructions on the Contacting a Detainee tab within each facility's webpage on ice.gov, if I'm on the right one. The list of detention facilities can also be found on ice.gov. Individuals can also reference information related to communicating with your client or prospective client on the Attorney Information and Resources webpage that's also on ice.gov. Please note that the referenced designated legal access points of contact or internalized resources who are leveraged to address legal access issues within the 25 field office.
So ICE ERO previously indicated they would try to provide as much notice as possible of a non-citizen's transfer within 24 hours after a transfer to another facility has occurred. Is ICE developing a nationwide system to confirm whether a detained individual has an attorney of record on file?
We're working on delivering and developing a centralized website that allows legal representatives to register for an account, complete, sign, and submit an electronic copy of the G28 form. In addition, there are tentative plans to include a scheduling tool that allows a legal representative to select a detention facility and schedule a call or a visit with their client that can be confirmed by the ERO office and detention facility.
And AILA respectfully requests that ERO give significant consideration against transfer if a non-citizen has retained counsel and a G28 has been filed with ERO. Will ERO consider giving this direction to the field?
ICE considers important factors prior to any transfer, including the detention center and the health, safety, and welfare of the non-citizen when determining if a transfer is appropriate. Transfer determinations are not punitive and based on a thorough and systematic review of the most current information available. Based on the standards, there is a reporting requirement that once your client has been transferred, Not only do they get free minutes to make a phone call at the new receiving facility, there's also a requirement that their representative is notified.
Thank you, Mr. Acosta. I think we're going to turn to Oakland now.
Yeah, let's turn to OPLA. We have a number of questions that were submitted in the build-up to this, and we're going to get to them, but we need to start with the elephant in the room. We had a court decision out of Texas that strikes down the Mayorkas memo, and it's set, unless there's an intervening stay, I think it's set to go into effect on the 24th. And I think everybody here at the table here and everybody in the room understands that OPLA's authority to exercise prosecutorial discretion is inherent in its role. It's not dependent on the Mayorkas memo or the Doyle memo. But we wanted to ask, where will this leave us after the 24th, assuming no intervening stay?
So Juan, I helped you out. So you're going to answer the question, this one for me?
Was I listening?
All right. Right. So Judge Tipton's order, as you know, as you just summarized, Aaron, vacated the Secretary Mayorkas's priority memorandum, the priorities he established. And while OPLA's PD memo was issued as a way to operationalize the Secretary's priorities for OPLA, as you pointed out, as all of you know, there are enduring principles of prosecutorial discretion inherent in our authority as prosecutors in the immigration court system. So at the moment, we're all in a holding pattern, and this applies to ERO as well. Broadcasts have gone out to the field, both OPLA and ERO, explaining that it's business as usual for the time being until the 24th. At this point, the government has authorized and filed, we filed the emergency stay with Judge Tipton, which was actually, to me, surprisingly, he did give us some additional time because the initial vacatur was supposed to go into effect tomorrow. And he gave us until the 24th. So that was a little bit surprising, just personally for me. I don't know, others in the government maybe were less surprised, but I think the intervening Supreme Court cases that came down with regard to the authority to sue the government in relation to their immigration policies and practices seem to have given Judge Tipton at least another, 2 weeks pause. So an appeal has been filed with the Fifth Circuit. Emergency stay has been filed with the Fifth Circuit. There were oral arguments in the Sixth Circuit in a parties case, the Arizona case, but that's heard in Ohio, so don't get too confused. But that case, the oral arguments were last Friday, and from the government perspective went well. So we'll see what happens. I think it may end up being battle of the circuits, but that's just me sort of speculating. But in the meantime, all of us are sort of talking internally. I know there's conversations going on with ERO, OPLA as well. We'll be sort of noodling this over to decide what it will look like after the 24th. We have to prepare for the possibility that the priorities memo will be vacated and what that will look like for both ICE as well as OPLA in support of ICE and our work in the immigration courts. As I mentioned, there is inherent authority for the trial attorneys as prosecutors to exercise discretion. We will have to figure out exactly what that looks like after the 24th. We obviously won't be able to rely on the Secretary's priorities as he outlined them in his memoranda after the 24th if the vacatur goes into effect. But so we don't know exactly what that's going to look like yet. We'll be working on that this week, or we'll be communicating to the field, to the OPLA field, and we're also in support of ERO and the decisions they make and providing legal counsel to them in determining how this is going to work. And we'll certainly be communicating with your AILA leadership to let all of you know. I hope that we will be able to continue in the work that we've started with the exercise of prosecutorial discretion. And I know we'll get to these questions that in our current process for exercising prosecutorial discretion, that we don't all see eye to eye on every case. And, appreciate that. And we appreciate you letting us know when you think things should be done differently. Again, we can't always agree to move in the direction you would necessarily like, but I hope that this moment of suspension while we're waiting to see what happens in the court will maybe remind all of us that the fact that we're able to issue a memorandum on prosecutorial discretion, move in that direction, is really something that we should all be supportive of, or understand that it's something that could be taken away shortly, at least to some larger extent. And that in the meantime, I've been doing town halls this week and meetings both in Dallas and in New York City, meeting with Opla Field's attorneys. My meeting in Dallas was part of training program, advanced training programs for Opla attorneys across the country. And a number of them told me that they were planning to work very hard this week and next week on their pending PD cases in light of the potential sunset of the Secretary's priorities. So I guess the bottom line is that we will believe that we continue to have prosecutorial discretion. How exactly that will play out if the vacatur goes through, we're still thinking through and trying to establish. We will establish some general criteria, but it will look different than what we're doing now. But we believe that it won't be the end of our ability to exercise our discretion.
So I understand it's understandably a work in progress for that contingency plan. But can you give us any idea of what to expect as far as communication to AILA or to the public in general about what that next step would look like? I mean, do you think we're talking about weeks, months?
Well, no, but we have to make a decision before the 24th. I mean, because not only, I mean, already, because as you may know, we ask our trial attorneys to update information on our Planet system, which is our litigation tools, electronic litigation tool that we use. It's a way for us to see what's happening in the field and get information from the trial attorneys. It's a big burden on them to do that, but it helps us understand what's happening in the field. Between that and also communications from all of you, help us see how things are going. And then obviously I talk to and work very closely with our field legal folks and with the chief counsels, and there's a lot of communication. So there'll be decisions before the 24th. I mean, there have to be. Some of it again is we're already working on some of this because we will likely have to amend our data tracking system because we won't be able to rely on the priorities to make decisions any longer. So that's already in the works, because if you don't all understand or realize this, moving the government in a certain direction, no matter what the decision is sort of like moving a large ocean liner. We can't turn on the spot. We're not that nimble because there's a lot that has to happen, a lot of systems, a lot of processes, a lot of clearances that have to happen before things are finally decided. So you will know, would it be 11:59 on the 24th? Maybe. I've, filed my share over my career of things at 11:59. But we will hopefully get that out before then. And as I said, communicate with you. I mean, likely we'll just have all the systems ready to go and then wait and see what happens, because, we could get another stay, hopefully, again, at 11:59 on the 24th, and then we won't have to implement these plans, but we can't sort of wait for that moment. So we're thinking and we're already planning of how this is going to affect us and what we'll have to do. And again, I know there's conversations already starting at ERO this week while I was out out in the field traveling, so I really have no insight on what happened, but when we get back, I'll get the updates and we'll see what's going on, decisions that need to be made. So as soon as we know and as soon as we've decided how we're going to implement any vacatur, we will broadcast to the field and we will make sure that we're transparent. And Francine Lynn Youngberg from ICE Office Public Engagement is here with us today, and she does an amazing job working with all of you and with her community relations officers around the country who work also with our chief counsels as well as ERO and HSI, their FODs and SACs out in the fields to really support and encourage communication with all of you. So we'll leverage all those resources and your AILA leadership as well to make sure that we communicate to everybody what's happening. But again, it's a quickly moving situation. So I think everyone has to be a little bit patient. And yes, we're already planning. We can't wait till last minute.
Okay, thank you. For PD requests right now, so moving back into the current under the Doyle memo, DHS says that they will notify respondents if they need fingerprints taken. Is there a way, I remember back in the day, I think it was for 237A1H requests, OPLA would generate a fingerprints notice for an ASC appointment at USCIS to run background checks that way because there was no application triggering it. So we wanted to know if there was a way that OPLA could generate that request so that USCIS could take prints.
Right. So that's interesting. So I'd be interested to know a little bit more because my understanding and sort of the guidance I've gotten from my field is that we don't have any ability to schedule or provide any sort of biometric notification. So basically where we landed, and that's explained in the Doyle memo, is that if you have a pending application already as the basis of the, you have a pending application, that can be the basis for either previously capturing biometrics or requesting an update of the biometrics. And that system, we can rerun those biometrics that were already captured. So for people who have no application and have nothing pending, yeah, we haven't really considered being able to request CIS to do that appointment. I will venture to speak for Director Jadot and say that I'm not sure they have the bandwidth to do that for us. And also, we're very cognizant of our colleagues at ICE ERO that help us run these background checks, that everybody's under a lot of pressure, both with their own backlogs and with the pressures of the immigration system as it moves forward. So I would be surprised if they were willing to do something like that. I'm happy to discuss it to see if there's a way to do it. But in the meantime, but even if they were willing, it can take a while. In the meantime, understand that getting a FBI fingerprint check does cost some money and take a little bit of time. But if you do the hard copy FBI fingerprint, go and get the hard prints done and sent off, I think it's $15. So it shouldn't be hopefully onerous for most people. I know previously when this was required, you could get electronic instant processing, and those were pretty expensive, $100 or $200. But
I think it's 50 and 18.
yeah. So, it would help us. And even if you have pending biometrics, if you provide the FBI fingerprint-based biometric report to us, that can save us some time, because otherwise we have to send the request to ERO and they have to run it, and they will do that in when they have the time. It doesn't happen instantly. I know some of our offices, some of the OPLA attorneys have access to those systems and will themselves do it, which adds to their work. But sometimes it can be quicker. But so whatever you can do to sort of be our partners to try to make these reviews happen a little more efficiently and to take some of the pressure off of us, because I hope you understand and realize that we are really have low staffing levels in a lot of our offices. Ideally, we should be 2.7 attorneys and staff to immigration judges. And there's a number of our AORs that have only a 2-person per judge, and some even have a 1-person per judge ratio. And it's just, now we've put all this PD evaluation requests onto our staff in addition to their regular work showing up at master calendars to individuals, and it's really, really difficult for them, sort of crushing workload. So we ask for your patience and we ask for your cooperation and try to make this move forward smoothly. So I know there was some confusion, maybe you'll get to this, but on one of the AORs saying that sounded like the fingerprints would expire and they had to reapply. I think it was just inartfully written. I think if you go back and look at the SOP, it's a little clearer now. So basically, if you've had biometrics taken in relation to an application, we can renew it and we can review that. You don't have to do anything additional. And we did that on purpose because I know there were issues with the interim memo in this regard. If you want to do fingerprint-based biometrics and supply that to us as a way to make it quicker and easier for us, we welcome you doing that. It's not required. If the person has no application whatsoever, at this point, we do ask you to get that FBI-based fingerprint check done. And however you can do it and afford to do it, that's great. I'm happy to ask if there's a way to generate a biometrics notice that the ASCs would be willing to do it, but I guess I'm not optimistic that that will be welcomed request, but I'm happy to ask.
Okay, thank you. So AILA supports the goal of prioritizing cases, but there's been some concern about motions to dismiss and the fact that that is the only form of PD that's being offered. Does DHS take into consideration factors such as the fact that a person has long been waiting for, they feel like they have a good opportunity for relief, they've filed applications, they're invested in that application, maybe there's a aging out child. Do they take that into consideration when considering and making the motion to dismiss? And I'm trying to consolidate a few of these questions together because we're running out of time. And there's been a lot of concern about them not offering stipulations to relief and only offering to dismiss.
So understanding first that the way we've created the operating procedures and we've rolled out the prosecutorial discretion is to have a streamlined process that will allow our frontline folks to quickly evaluate a case and decide whether it's a priority or non-priority. And as you know, our preferred form of prosecutorial discretion is the dismissal. And so it just doesn't allow for, in many cases, an opportunity to fully evaluate each case individually. I mean, I wish I had, instead of 1,400 attorneys, 2,800 attorneys, and then maybe I would have the time, our staff would have the time to review every single case on an individual basis, but we just don't, and we just can't. So what I would say is that if you have a particular case that, for example, someone's aging out, or there's a really compelling factor that would lean in favor of an alternative form of prosecutorial discretion, please let us know as quickly as possible. I know that on our public-facing website, you have the chief counsel's emails and the PD request emails. I guess I would also remind you and ask everybody for their consideration that we've posted the chief counsel email in relation to prosecutorial discretion as a way to facilitate prosecutorial discretion, not as a way for you to email our chief counsels to ask them who the trial attorney is going to be the next day in court or to find out if a case has been assigned. So that's just not appropriate. And our chief counsels don't have the time and ability to respond to the more sort of mundane requests. So we ask you please to try to be more judicious in how you use those emails, and that they really are to facilitate PD. And if you want to set up stakeholder meetings and the like, I'll talk a lot faster, sorry. So I think that stipulations are definitely part of the process. And if you would like a stipulation, is to try to get to us as quickly as you can to notify us that that might be preferable and why, because we're going to weigh those factors to do it. And we've definitely sent out the message to the field to say that they should use their common sense. If we've got a case coming up that they agree is a very strong case, that they feel able to stipulate to all or part of either the facts or the law, that they should exercise that discretion. If a case goes sideways, please reach out to chief counsel. I know we were talking earlier, at least one case I'm aware of where they decided to do a joint motion to withdraw the dismissal and put the case back on the docket. I mean, we will try to do our best if a case really has gone sideways, but please understand that, that again, we're doing the best we can with the limited resources and really trying to be able to focus on the priority cases.
I want to drill down on that for a quick follow-up. So A lot of times our members, the first time they know that the case is going to be set for a motion to dismiss is when they get it in the mail, right? The motion in the mail. So where they get that and they think they can make a great case for dismiss, for stipulation or something else, sometimes they know that the IJs are likely to rule in favor of the dismissal over their opposition. And so as an alternative to just writing an opposition and then having to appeal it to the BIA and having both parties brief it to the BIA, will DHS attorneys consider filing a motion to withdraw their motion to dismiss as an act of prosecutorial discretion?
Right. So certainly if the case merits it, if the trial attorney believes the case merits it, it's not prohibited, and it certainly would be something that would be on the table. And I know that, again, sort of communication can be difficult when we're all sort of, rushing towards the next court hearing. But, absolutely on a case-by-case basis, if it compels that, I think that would be something that our field would be open to doing.
And it's interesting because what we're seeing is the oral motions being made at the master and with no notice.
Mhm.
And
Yeah. I mean, our priority right now is to deal with the master calendars as they're coming up and the individual hearings that are coming up. So if you have an individual or a master coming up in the next month or 2 months, please understand your case is going to be reviewed for PD. And when you walk in there, there may well be a motion to dismiss. So you should be prepared for that. I want to, give you that flag that is what we're doing, is that we're, right now working on June and July, and then we'll be working on August and September, and as a way to process those cases out. So, yes, that's what we, from our side, think should be happening. And so just be aware that may be coming when you appear for your master calendar hearing.
And moving on to joint motions to reopen or remand, can you confirm that all OPLA offices should be considering requests for joint motions to reopen or remand?
Yes, so we will definitely consider joint motions to reopen and joint motions to remand. Again, it's a matter of resources. Like right now, since April 25th, when the Doyle memorandum came into effect, our focus again was on the masters in May and the individuals in May and June and so forth. And so unfortunately, just because of the burdens that we're under, joint motions to reopen are not a priority, and it may take us a while to get to them. But if you filed and requested, we will get to them. It just might take a little while. If you've got a case in the circuit court, like you filed a petition for review, reach out to OIL. OIL will sometimes contact us. There's a footnote, I think, in the memo that talks about this, but OIL, we have a system for them to kind of notify us and say, there's this case coming back, we'd like to send back. And especially if it's someone reclaiming permanent resident status, that's a particular priority to have it come back and get it dismissed and so forth. So reach out if there's some timeline or emergent issue in the case so that we can try to address it. But if it's a standard joint motion to reopen for someone, and again, ERO is functioning under the same priorities as we are. And so if it's a non-priority case, there's not necessarily a compelling reason for us to drop everything else we're doing to get to that joint motion to reopen. And so that would be a place where, again, I would ask for your indulgence and patience with us. But if you filed it, we will get to it. I just can't say when exactly.
And will OPLA consider PD at the BIA stage if the respondent resisted dismissal before the IJ?
Right. So that's really tough because we are leaning very heavily to ask you to exercise your discretion at the earliest possible moment, and that we are not really amenable to you opposing discretion, losing your case, and then trying to ask us to dismiss the case at that point. That sort of undermines the whole purpose of this, which is to not spend time and resources on non-priority cases. So you need to make a decision, a strategic decision with your client, whether that's really what they want to do. So we would be, it's obviously a case-by-case basis. If there's emergent issues, new evidence, new information, we will 100% take that into account. But if it's just a strategy decision, we're not going to be positively inclined to assist your client in that regard, I would say, as a general rule, but, make your case.
The red light is flashing at us,
Yes, I
saying
know.
that time is up. I wanted to thank Kerry, Doyle, and Juan Acosta for being here and for their engagement. I'd point out that I definitely appreciate the engagement that's going to be needed in the upcoming weeks and months, I think.
Yeah.
And yes, thank you for your time, and thank you to the audience for the questions.
Great. Thank you, everybody.
Thank you.